All right, we'll get started. Make sure your mics are on. We've got 5 of us here. Like I said, Frank said he couldn't make it, so we should be good to go. There was no March meeting, so we'll look to the February Board of Adjustments minutes. Can everybody look over those, and if you have any questions or comments before making any motions? Everybody good? Anybody want to make a motion on those?
I'll make a motion to approve the minutes.
Okay, thanks, Ursula. A second?
Okay.
Thanks, Clem. All those in favor for the February minutes?
Aye.
Aye. Any opposed? Okay, February minutes are approved as motion. And Charlie, you want both of these, right?
Yes, sir.
One. Do you need me to date them?
No.
Okay. Okay. And then Charlie will swear in anybody that needs to speak, and also if you could sign in if you're speaking as well, if you haven't done so. Go ahead, sir.
If everyone who signed in to speak or who's preparing to sign in to speak, you can stand and raise your right hand, please. Do you swear or affirm the statements you're about to make to be the truth to the best of your information and belief?
Yes, sir.
Thank you.
Okay. The old application, was it postponed, or is that saying it was postponed from before? Okay. So the old,
Yes, sir. It was,
Okay.
it was postponed at the request of the applicant to a monument sign.
right.
That was not what the original application was, and they had changed it after notices had gone out. So they agreed to postpone it to that May date with a different type of sign.
Okay, gotcha. So with that one being taken care of, we'll go to the new applications A. Just make sure your cell phones are silenced and your mics are on. Take it away.
All right, first application of the night, G 2026-08. It's a variance to reduce the side yard setback minimum from 7.5 to 0 feet, as well as 2-dimensional lot variances to reduce minimum lot size for 10 to 15%, as well as reduce minimum lot width by 33%. The location is 235 Tambark Drive. The zone is R2 medium density residential. Surrounding zones are R2, B2, and R1C. Lot size is 0.3 acres. Direct access is Tambark Drive. Arterial access is McClellan Circle. And staff does recommend approval for this application. Seen here is aerial photos of the site. The application would split it down the middle there. You'll see in the plats here. There's our zoning map. You can see the R2, the R1C, B2. So some context. The application is for those 3 variances mentioned. The variances are intended to facilitate the division of that existing duplex lot into 2 separate parcels or properties, which would just allow for individual home ownership. The townhome style building at that address already exists, and that existing lot was created legally as Lot 32 of the Forest Oaks subdivision. KRS 102.243, findings necessary for granting variances. Before any variance is granted, the board must find that the granting of the variance will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause a hazard or nuisance to the public, and will not allow an unreasonable circumvention of the requirements of zoning regulations. The board shall consider whether the requested variance arises from special circumstances which do not generally apply to land in the vicinity or in the same zone. The strict applications of the provisions of the regulation would deprive the applicant of the reasonable use of the land or would create unnecessary hardship. And then the circumstances are the result of actions of the applicant taken subsequent to the adoption of zoning regulations from which relief is sought. The board shall deny any request for a variance arising from circumstances that are the result of willful violations of the zoning regulation by the applicant subsequent to the adoption of the zoning regulations from which relief is sought. So the comprehensive plan indicates that there's a mismatch between the current household sizes in Georgetown-Scott County and the number of smaller dwelling units being constructed. The document also indicates the need for middle housing in the area, defining townhomes as an example of such. And as a goal or objective, it states that the community and legislation should encourage the expansion of affordable and middle-income housing opportunities throughout the community. So staff does find that this application, in allowing for the ownership and use of traditional townhomes, would fill that need for missing middle housing as identified by the comprehensive plan. So as it pertains to reasonable use under KRS, zero lot line arrangements are not uncommon for duplexes or other attached single-family structures, as they allow for the independent ownership of units. The zoning ordinance does not technically grant this use by right because of R2 minimum dimensional and setback requirements. And those three variances mentioned before would be required for the platting as proposed to occur. So further regarding reasonable use here, strict interpretation of the ordinance in this case would deprive the reasonable use of the intended by right townhome style use of this R2 medium residential density property. The ordinance lists single-family dwellings, which includes townhomes, as a by right use in the R2. The setback provisions for the R2 would effectively prohibit the use of townhome-style zero lot line housing, and denial of the requested variance would create hardship and deny reasonable use of the land for the applicant or the users of the parcel, as it would not allow for independent ownership of the single-family units at this location. So seen here are the three dimensional lot variances that are being requested. In the green, you have the minimum lot size. You've got that reduction from 7,500 square foot minimum in the R2 down to 6,362 for the smaller lot and 6,700 for the larger lot. And that's about a 15 to 10% reduction. Outlined in purple is that reduction in the setback line where those townhomes are going to be right up next to each other. And then outlined in the orange, with the orange arrows, is the reduced lot width down by 33% for both parcels. So though we do have that reduction in proposed lot size from those typically established minimums, the density of the two parcels would not violate the maximum R2 density of 12 units per acre. So staff does recommend approval of the reduction in these minimum lot dimensions, really based on the finding that the reduction of R2 minimum dimensions in this case is not unreasonable, and that the lots created by these dimensional variances will not violate density maximums. So findings: project site is a 0.32 acre parcel in the R2 zone. Those zero lot line arrangements are not uncommon for duplexes and other attached single-family structures, as they allow for the independent ownership of units. The zoning ordinance does not technically grant such a development practice by right through technicality. The strict or literal interpretation of minimum dimensional standards would deprive the applicant of reasonable use of the land, in this case, individual ownership. Denial of the requested variance would create hardship. Approval of the variance would not create a situation that is not in line with the general character of circumstances afforded to other attached single-family structures. The reduction of minimum lot size is acceptable in this specific case, as all other setbacks will be met, safety standards will be ensured, and maximum R2 density will not be exceeded in the case of either parcel. And then, as last finding, documentation of firewall, where those two townhomes will be adjoining each other, will be needed for any kind of approval or implementation of this. So staff does recommend approval of this variance to reduce the R2 minimum dimensional standards to facilitate the creation of separate townhome lots. We have our standard conditions of approval, And then we also have 2 unique conditions. 3, the applicant must provide certification on the new plat from a certified licensed home inspector, ensuring the existence of a proper firewall separating the 2 units being divided, and shall comply with any request from staff, the board, or building inspection officer pertaining to the wall. 4, the applicant shall acquire approval from and comply with all requirements of all utility or service providers to the site prior to final recording of the subdivision plat for this application. So having covered all of that, does the board have any questions for staff at this time?
Any questions? Is there anybody else who wishes to speak on behalf of this, either for or against?
Staff was advised ahead of the hearing that the applicant for this application and the next would not be present.
Okay. Anybody else that wishes to speak? Okay. Any other questions from the board, or would anyone like to make a motion?
Can you explain one thing to me, the firewall you're talking about?
Yes, ma'am. So regarding the firewall, because this application would facilitate separate ownership of units,
Right.
it is a kind of a legal liability thing that we want to ensure that that firewall is put in so that if a fire starts on one lot, it does not immediately spread over to the other.
Right.
I will say that the submitted subdivision plat has the signature of the building inspector, that it would be feasible for that firewall requirement to be met. Does that kind of address your question there?
Yeah, that's what I was wondering. Okay, right.
Yeah.
Okay.
There's not currently a firewall between the 2 units?
No, ma'am, not to my understanding.
Okay, thank you.
Any other questions on that? Okay. I'll make a motion to approve, based on staff recommendations.
Second.
Ursula, second. All those in favor? Aye. Any opposed? Okay. Motion passes as presented. Thank you. We can go ahead to B for
All
new
right.
applications.
We have almost the exact same thing for the second application. G 2026-09. It's very similar in terms of the variances. It's that reduction in minimum R3 side yard setbacks from 7.5 to 0 feet. Got the variance to reduce minimum lot size from 7,500 square feet to 3,961 or 5,500 square feet. And then you have that last variance to reduce the minimum lot width by 42% to 0.63% for the larger parcel. The zone is R3. The location is 345, 347 Williamsburg Lane. Surrounding zones are R2 and A1. Lot size is 0.216 acres. Direct access is from Williamsburg Lane. Arterial access is from Cincinnati Pike, and staff does recommend approval on this application. Here's the aerial view of the property in question. You can see that that existing townhome setup does already exist there. And here is our zoning map. So similarly to the last application, it is for 3 variances to reduce the minimum R3 side yard setback from 7.5 to 0 feet, to reduce the minimum lot size, to reduce the minimum lot width by 42 to 0.63%. The variances are intended to facilitate the division of the existing duplex into 2 separate parcels of properties, allowing for that individual home ownership. The building already exists as seen in those image references, and the existing duplex was created legally as Lot 32 of the Forest Oaks subdivision, the existing property, I apologize. So KRS 100.243, won't read this all over again, but that's there. Comprehensive plan, once again, indicates that we have the need for housing of this type. that missing middle housing, and that this application can play a role in fulfilling that need as identified by the goals and objectives of the document. So reasonable use under KRS 100-243. Those zero lot line arrangements are not uncommon. The zoning ordinance does not technically grant that reasonable use by right because of minimum R3 setbacks. And those 3 variances mentioned before are required to allow for the platting to occur. So the strict interpretation of the ordinance would deprive the reasonable use of the R3 property. The ordinance lists single-family dwellings, townhomes as by right use. The setback provisions for the R3 would effectively prohibit this use of townhome-style housing. And denial of the variance would create hardship or deny the reasonable use of the land because it would not allow for independent ownership of the single-family units. So seen here similarly in the green there on the plat, you have the first variance, which is that reduction in the minimum lot size for the R3 from 7,500 square feet to 3,900, 5,500 square feet respectively. And that does entail reduction of 30% for the smaller lot and 60% for the larger lot. In the purple there, you have that reduction in the minimum setback line from 7.5 to 0 feet. And then in the orange, you have that reduction of the minimum lot width, ranging from 40% reduction for the smaller lot and 0.63% reduction for the larger lot. So though there is that reduction in the proposed lot size, the density for the R3 will not be violated by the parcels being created by this application. So staff does recommend approval of the reduction based on the following findings. It is not an unreasonable reduction of dimensions, and the lots created by these dimensional variances will not violate the density maximums of the R3 zoning district. So findings: the project site is a 0.22 acre parcel in the R3 zone. Zero lot line arrangements are not uncommon, and the zoning ordinance does not grant this by right through technicalities. The strict or literal interpretation of the minimum side yard setbacks and the minimum dimensional lot sizes of the R3 would deprive reasonable use of the land in this case in the form of the ability for ownership. Denial of the variance would create hardship, and it would not allow for that independent ownership. Approval would not create a situation that is not in line with the general character or circumstances afforded to other attached single-family structures. The reduction of minimum lot size is acceptable in this specific case, as all of their setbacks will be met, safety standards will be ensured, and maximum R3 density will not be exceeded in the case of either parcel. And then lastly, documentation of firewall must be approved by the building inspector. So staff does recommend approval of these 3 variances at the property address 345, 347 Williamsburg Lane, including the reduction of the side yard setback, the reduction of minimum R3 lot size, and the reduction of R3 minimum lot width. And then we have those 2 unique conditions of approval. The applicant must provide certification of the firewall, and the applicant must comply with all requirements of utility or service providers prior to final recording of the subdivision plat. So having read that off, does the board have any questions for staff at this time?
Can you go back to the first screen for that, the first page? The
Yeah.
very first one? Yeah. Okay, I think on our packet, the address was wrong for the location. I don't know if you need to
Yeah, I
change
believe
that or alter that.
Yeah,
but-
Ashton Grove Path.
Yeah, I believe I
Yeah.
misentered the address
Well, and I
there.
think our packet says, mine says Tan Bark
So does mine.
from the original one, so,
The address is 345, 347 Williamsburg.
right, which
Lane.
is, that's what it says at the top, but the
Okay.
location, so,
I apologize for that.
just to make sure you had them correct, that's
Okay.
all I had.
Yeah, corrected for the record.
Yes, ma'am.
Any other questions for staff? Any questions? Any others? Would anybody like to, if there's no other questions or comments, I'm sorry, does anybody from the audience wish to speak for or against this? And same applicant, correct? Okay. Any other questions or comments before someone like to make a motion on this?
Make a motion to approve based upon staff recommendations.
Okay, Ursula, thank you.
Second.
Okay. Thank you. Ginny? All those in favor? Aye.
Aye.
Any opposed? Okay, motion passes as presented. Thank you. We can go ahead to C.
All right. Third application of the evening, 1141 Lexington Road, G 2026-10. Variance requested for the display of 2 wall signs. The property is zoned B2. Surrounding zones are A1 and P1. Lot size is 4.03 acres, and then both direct and arterial access is from Lexington Road. And staff does recommend denial of this application. Seen here is an aerial view of the property in question. Here is the zoning map. KRS 100-243. We've read that already. So some background. The application for before the Board of Adjustment is for the display of 2 wall signs. The church that inhabits the current property, the property currently, was established as a conditional use in May of 2009. The sign ordinance provides that any building may have 1 wall sign per street upon which the building fronts, and the church building under current conditions has frontage upon 1 street upon Lexington Road. So the applicant requests that variance in the form of 2 wall signs to be displayed towards the street frontage, and the application material depicts 2 separate wall signs. One that is already displayed, the text wall, and the other is a logo that has not yet been put up. So the application material states that the 2 wall signs in question would constitute 1 single wall sign, citing it as a single identifying element designed to fit the proportions of the building. Staff does find that the sign ordinance with the 2 figures listed below here does define any single display face separately displayed is a separate wall sign to itself. So this is application material submitted by the applicant. That text wall there on the right is existing currently on the site, and the logo on the left is their planned current sign. So regarding KRS 100-243, the variance shall not affect public health, safety, or welfare, will not alter the essential character of the general vicinity, and will not, unreasonably circumvent requirements of zoning regulations. The sign ordinance does make the provision that only one wall sign may be allowed per street upon which the building fronts. And so in allowing 2 wall signs towards a single street on a building that only has single frontage, that is in itself unreasonable circumvention. The dimensional area of the sign shown on the application would be in excess of the minimum display area for wall signs in the B2. Wall signs are granted up to a maximum of 150 square feet, and the dimensions of what is shown on the application would be around 165 to 170 square feet. So the granting of the application would grant what is something that's in excess of the typical wall signage display maximum. So the variance would create unreasonable circumvention. The requested variance arises from special circumstances which do not generally apply to land in the vicinity or in the same zone. The applicant argues that special conditions exist as the building has a wide and unbalanced facade requiring uniquely distributed design philosophy regarding the display of signage. Staff finds that this is not a unique circumstance and that it does not necessitate a variance. The applicant states that strict interpretation of the ordinance would deprive rights already exercised by similar institutional or commercial entities, and they cite precedents of similar buildings or uses with multiple wall signs. And that includes crosses that are displayed by other, religious symbology that's displayed by other churches in the nearby area. And so staff finds the following in regard to that claim. Crosses or other religious symbols do not constitute a wall sign, do not constitute a sign as defined by the ordinance. and other non-conforming signs or sign variances do not create any precedence for the granting of other variances. Similarly, in regards to hardship or denying reasonable use, the application material submitted requests any of the following three options. One unified architectural feature of the display of signage, one coordinated wall sign, or the requested variance for two signs based on the criteria outlined in the application material. So because the application indicates acceptable alternatives that would not require a variance, denial of this application would not create unreasonable hardship. Furthermore, the other reasonable alternatives to the two wall signs exist with that indicated intention of balancing aesthetic character because the display of religious symbology would be defined as an exempt sign, and it would not require a variance to display. So findings, the site for this application is a 4.03 acre parcel zoned B2. The signs depicted in application material as defined by the ordinance are two separate wall signs. The variance regards the display of the text as and logo as distinct and separate signs. Should the applicant elect to display both the text and logo as one single continuous display face, the sign would require a dimensional variance if it will be over 150 square feet. The display of exempt religious symbology on the facade of the building would provide the intended aesthetic or architectural balance without requiring a variance. The granting of the variance would create unreasonable circumvention because the ordinance makes the provision that there may only be one wall sign for one building with frontage on a single street, and the sum total display area of these two signs would exceed the maximum display face for wall signage in the B2 district. And lastly, the indication of acceptable alternatives to the variance in the application material reveals that denial would not create hardship or deprive reasonable use of the land. So staff does recommend denial of the variance request for the display of two wall signs on 1141 Lexington Road on the basis that it does not meet the standards of state statute. Conditions of approval, we have our typical conditions, and we have unique conditions in the form of 4, 5, and 6. All other signage on site, such as wall signs, must meet the requirements of the Georgetown sign ordinance. The total dimensional area of the two signs shall not exceed 150 square feet, and the applicant shall acquire sign permits from building inspection. Does the board have any questions for staff at this time?
Questions? Comments, anything?
Is the applicant here and would like to speak?
The applicant's not present? Is there anybody else that wishes to speak on behalf of this or against? Wow, that is surprising.
Yeah.
Okay. Any questions or comments from staff on anything?
No.
Okay, would anybody like to make a motion?
I move we deny the application on the staff recommendation.
Okay, thanks, Jenny, the motion,
Second.
Clem, second. All those in favor?
Aye.
Any opposed? Okay, motion passes as presented. Thank you. D,
Okay. Fourth application of the night, G 2026-11. Conditional use permit for a hospital, 3-bed assisted living facility, or nursing home. The issue of defining it is a little bit difficult. It is a nursing home to be operated out of an existing home for the property addressed 498 North Shoshone Trail. The location is 498 North Shoshone. Zone is R1B. Surrounding zones are R1B, A1, and R2. Lot size is 0.3 acres. Direct access is from North Shoshone Trail, and arterial access is from Lexington Road and Main Street. And staff does recommend approval of this application. Seen here is just the aerial imagery of the site. You can see the existing home on the property there. Seen here is the zoning map. So to begin with the comprehensive plan, the comp plan does emphasize the idea of aging in place or allowing for aged persons to remain in Georgetown with flexible home care options. The housing objectives of the adopted plan does indicate the following two priorities as it pertains to elderly care. Housing for one, increase the availability of assisted living facilities and shelters. And for two, increase availability and flexibility of housing options for elderly residents. And staff does find that this use would play a role in meeting the need identified by the comprehensive plan. So proposal, scale, and form. The proposal is for the operation of a 3-bed nursing facility for elderly care out of an existing home on 498 North Shoshone. The applicant has stated that no more than 3 patients will be on site at any one time. The use will be staffed by a total of up to 4 employees, to include the applicant, a nurse, and 2 hired certified nursing assistants. The applicant has stated that clients will remain on the site for extended periods of time. Staff on the site will provide nursing care and quality of life assistance to the residents 24 hours a day. And there are no previous Board of Adjustment applications for the project site. So staff does find that the use may reasonably fall under the definition of a conditional use for a hospital for human care because it is a nursing home facility. And we'll kind of work into the issue of defining the use later. So with the extended stay period of clients, the application may constitute a use that is residential in nature. If clients are to remain on site for an extended period of time, they will, in essence, kind of become residents on site. And so, as a result, staff does find that it is generally consistent with the residential zoning intention of the site. So the applicant has indicated that there will be essentially no exterior evidence aside from parking and the ADA accessible ramp. And staff does find that this evidence is not different from the exterior evidence of any other place of residence. You know, any home may have multiple vehicles parked outside or an ADA accessible ramp to the front door. And staff does find that this use, given its limited scale, will not generate any immediate or articulable effects on the surrounding area. So in terms of defining the use, and this is where this application gets a little complicated. The original application material is for an assisted living facility, but the ordinance does not provide for assisted living facilities in the zone of this site. And the nature of the proposal similarly does not fall under the definition of an assisted living facility. The ordinance, section 2.1, defines assisted living facilities as follows. It's a building, establishment, or complex, or distinct part thereof, which accepts primarily aged persons for domiciliary care, not nursing or medical care. And since this proposal is to provide nursing care specifically, it does not necessarily fit that intended definition of an assisted living facility. So the nature of this proposal most closely fits within that of a nursing home. And the ordinance does not define a nursing home. It doesn't list nursing homes as an allowable use in any zoning district, despite the comp plan indicating the need for uses of that nature. On the other hand, hospitals for human care are listed as an allowable conditional use in all residential zoning districts, though the ordinance also does not define what constitutes a hospital for human care. So in this situation where we have these uses and they are not defined, the ordinance makes the provision that any words or phrases not defined shall be given their ordinary meaning or usage. And so the ordinary dictionary meaning is going to be outlined here. So the Cambridge Dictionary defines hospital as a place where people who are ill or injured are treated and taken care of by doctors and nurses. Merriam-Webster defines it as a charitable or having the quality of providing help institution for the needy, aged, infirm, or young. And so the question is whether this specific application for a nursing home may constitute a hospital for human care. Staff also finds in relation to this use that the nomenclature of a hospital for human care rather than simply a hospital does inherently broaden the range of what may fall under the umbrella of that term. And regarding this use as a nursing home, the general definitions are going to have to be used again because the ordinance does not define it. So the National Institute on Aging defines a nursing home as a place which provides a wide range of health and personal care services. The services focus more on medical care than most assisted living facilities or board or care homes. Services offered in a nursing home typically include nursing care, 24-hour supervision, 3 meals a day, and assistance with everyday activities. And so that aligns most closely with what is proposed for this application. The term is also generally defined, a nursing home is also generally defined as a place where very old people who are ill live and receive medical treatment and care. So staff does suggest making the determination that the form and function of the application fits within that of a nursing home rather than an assisted living facility because it provides 24-hour residential nursing care for aged persons. And staff also finds or recommends finding that the nursing home fits under the general definition of a hospital for human care in regard to that primary function of providing a level of medical or nursing care to those who are in need of it. So for the purpose of the board's consideration, staff does find that this application would constitute the use of a nursing home, which is in itself a hospital for human care and allowable use in the R1B. And so now that we've kind of looked at defining the use, we're going to kind of get into the specifics of what this would require to the letter of the ordinance. The property adjoins A1 zoned land to the east and the north. There's kind of that whole of unincorporated Scott County right in the middle of Georgetown there, where you have that A1 zone land. And the landscape and land use buffer ordinance would require each of the following 3 items because this is increasing the intensity of a use through the conditional use permit process. It would trigger each of these things. It would require a 6-foot tall no-climb boundary fence wherever the site adjoins the A1. It would require a minimum 50-foot setback where it adjoins the A1, and it would require a minimum 50-foot landscape buffer also where it adjoins the A1. Similarly, in terms of development standards, the subreg, because we are defining this as a hospital, the subregs make the provision that a hospital must meet the following off-street parking requirements. It requires 1 space per 2 beds, plus 1 space per doctor, plus 1 space per 2 employees on the largest shift, plus 1 space per hospital vehicle. So there are no parking metrics for nursing homes outlined in any local zoning documents. And according to this metric, with the 3 beds and up to 4 employees, no hospital vehicles, the use would require 3.5 parking spaces. And staff does find that given the scale of the site and the relatively small driveway, the site may not be able to reasonably accommodate such a parking metric. And so, through the literal interpretation of the ordinance, those requirements of the landscape buffering, the fence, and the parking spaces would be required. And staff notes that this may not be necessary in this case. But it is also noted, it's noted that because the existing regulations don't define or even entertain nursing homes as a use, the regulations may not be applicable here. And because there has been no relief from these requirements formally requested, and there is no development plan, staff isn't going to recommend any kind of variance or relief from these requirements. What we recommend is a condition of approval that a preliminary development plan be brought before the commission so that we can kind of ensure that all of those development standards are kind of properly evaluated to see if this can reasonably fit here. So regarding findings, the project site is a 0.3 acre property zoned R1B. The comp plan, in emphasizing the need for flexibility of housing options for elderly residents, does indicate the need for this use. Staff finds that the proposed use is necessary for the well-being of the community in that it provides service to a group of persons in need of it. The original application was a conditional use for an assisted living facility, but this is not applicable because the zoning ordinance does not list assisted living facilities as an allowable use. And similarly, the nature of this use in providing nursing care does not fall under the definition of an assisted living facility. The application in providing nursing care constitutes a nursing home. Nursing homes fall within the definition of a hospital reasonably, and a hospital for human care is an allowable conditional use in the R1B. Because the general definitions for a nursing home indicate such a use as a residential facility, the use is consistent with the residential character of the R1B. The zoning ordinance lists hospital for human care as a conditional use in all residential zoning districts. Proposal is low scale in nature with no more than 3 clients and 4 employees on site at any one time. With appropriate conditions, the use will not negatively impact the public health, safety, or welfare, and it will not negatively impact the residential character of the surrounding community. And because regulations, as we covered with the landscape and land use buffer ordinance and subdivision regulations, would require those really specific development standards for this use, staff recommends a development plan as a condition of approval to more formally evaluate it in relation to those requirements. So staff does recommend approval of the conditional use permit for a hospital for human care on the basis that the comprehensive plan indicates the need for uses of this nature, will not alter the character of the surrounding area, and it falls under the allowable conditional use of a hospital for human care in the R1B. We have our standard conditions of approval, and starting at 5, we have our more unique conditions. All parking must be off-street on the existing driveway. There shall be no exterior evidence of the home business outside of a small wall sign not to exceed 5 square feet. Any severe medical conditions or issues for any clients housed on the site must either be treated off-site at a more specialized hospital, or if treatment is to be administered on site, it must be administered by a resident or by a registered nurse or doctor that is qualified to do so. There must be at least 1 registered nurse or CNA on site at all times. Any and all potentially hazardous medical materials or equipment, such as oxygen, if they are to be stored upon the site, shall have any and all necessary safety permits from appropriate issuing authorities. And lastly, staff does recommend requiring that development plan, particularly in relation to the issue of parking plans, minimum buffering, setbacks and screening standards where the site is adjacent to the A1, and lastly, just to see specific dimensional details of the proposed use. Does the board have any questions for staff regarding the application?
So on the conditions of approval for number 1, that ties back to the 3 developmental standards listed, correct?
Yes.
That ties into number 1, okay. I just wanted to make sure on that. Go ahead.
On your findings 4 and 5,
Yes, ma'am.
the application is for an assisted living facility. Who made the transfer to the nursing home? Did the applicant submit a new application?
Holden, would you mind speaking to this?
Yeah, and so this is kind of a quirk in just the application process. From staff's perspective, the application was filled out that provided what they believed the closest use would be, and then they explained what that use would entail. And so in looking at what the use would actually entail, We believe that they inappropriately identified the use as an assisted living facility when it should have been, as you've now defined, a hospital. And so the application, the materials, the use have not changed nor been altered by anybody. It's just what we would formally call this use. And in that case, staff believes I correctly identified it as a hospital.
So the applicant was not consulted in that change?
No.
So we did have conversations with the applicant regarding how we would define the use. We did notify them that that assisted living facilities were not an allowable use in the R1B district, and we did indicate that we were going to need to define it as a hospital for this application to move forward for the board's consideration.
Go ahead. Anybody else? Questions? Can you talk real quickly about the parking? Again, I'm kind of confused on what needs to be done there. I know number 6 says it must be off-street and on the existing driveway, but I know it looks pretty tight, and then you said they had to do some kind of parking plan.
Yeah, so really that is to address the concern about off-street parking, or on-street parking, I'm sorry.
Correct, yep.
And how that would, obstruct traffic flow for the
Right.
nearby residents or neighbors. Part of that also is a technicality, because we are defining this as a hospital. It is then technically held to the development standards of a hospital. That is unfortunately kind of a technicality of the way that our ordinance is written. And that's why we recommend the development plan, so that we can consider these things down at a finer level.
Okay.
And if variances or waivers are necessary, it can go to the planning commission for that consideration.
Okay.
Will that parking plan have some sort of capability to allow for access by an EMS vehicle? I
We
mean,
can-
otherwise, the employees' parking could block it in the driveway.
Yeah, we can condition
I would hope
that.
so, yeah.
We would condition that appropriately as we reviewed it during our review process at Technical Review Committee and, in the final staff report.
Okay. Any other questions or comments from staff? Is the applicant here that wishes to speak, or anybody else for or against? Okay. Yep, sure, go ahead. And everybody's been signed in, swore in? Okay.
I have signed.
Okay,
and I have
just
sworn in.
state your name before speaking and
Harold.
go right ahead.
Harold Sims, attorney, representing Miss Mary Watson, and her, I think her son also is the owner of some adjoining property, Bob Watson, and his family members. There's several matters that are really concerning on this application. My clients are, first of all, be very clear that they're opposed to the granting of this application. I want to start off with addressing a fundamental process from my standpoint, from the public standpoint, is a matter that you don't always hear of in a Board of Justice meeting, but is the concept of due process, and that the public, as at least the zone of interest members of the community that received notice of this application, it said it was for an assisted living facility. And when you, assisted living facility is very clearly defined in our zoning ordinance, and this facility, by the applicant's own description with staff, does provide nursing and medical care, and that is outside the bounds of a traditional assisted living facility, and outside the bounds of the defined assisted living facility under our zoning ordinance. That zoning ordinance was just adopted in 2025. I've lived here since 1975, and the zoning ordinance came into effect in the late 50s. I know there were nursing homes that were approved in this community and they're still not in the ordinance. Assisted living facilities are in here. Applicant chose to file an application for a assisted living facility. That's what the neighbors, my clients, thought we were preparing to challenge, and then when the staff recommendations came out, there's been some crafty wordsmanship that turns it into a hospital for human care. Now, that is a kind of a tortured phrase, but I guess there are pet hospitals, and nobody would want a pet hospital in a residential facility. But I think I think this board has to consider hard. I think that first of all, I think our comprehensive plan that adopts as a goal for the community aging in place and more domiciliary options for our elderly public is a laudable goal, one that this community should pursue. I think this application is an overreach, an attempt to satisfy a goal and objective of the comprehensive plan that's going to take you down a road that maybe has unforeseen consequences here. I started thinking about what are some other hospitals for human care. Well, a mental health facility is a hospital for human care. Are we going to start to approve many homes for mental health facilities in residential neighborhoods? Closed head brain injuries are something you see regularly in communities these days. That there are facilities where people that have closed head brain injuries, they don't necessarily function, they don't necessarily have daily medical care needs, but they need assistance with daily living. So I think taking a term like hospital for human care and pigeonholing it in order to meet a goal for the comprehensive plan to help there be some assisted aging facilities is an overreach that I think you may have to rethink at some point in time in the future. And that's why we have the goal of trying to know what the public gets notice of an assisted living facility, and they says, well, this clearly does not meet the goal of the definition of an assisted living facility, so how would this get approved in this zone? And so the application's kind of been changed to fit the comprehensive plan, and I don't think that's necessarily part of what's going on here. And I believe the real potential here is an outcome that may lead you to somebody else to want a different kind of a hospital for human care, not necessarily to meet the goal and objective of the comprehensive plan to assist elderly living, but you've created a slippery slope that says we want to have, if it's for the providing of a hospital for human care facility, can we approve that in this neighborhood? So I think you need to, right off the bat, I'm a little bit concerned about how the application makes a jump to satisfy the comprehensive plan without necessarily everybody getting ready to prepare that, and I'm not sure that all the neighbors understood it that way. Moving on to the issues of whether or not this is a good idea for this neighborhood. I do think you have to really stop and consider it. Is it going to change the complexion of the neighborhood? It's one of the goals of a conditional use permit, is it's not going to necessarily change the complexion of the neighborhood. This is clearly, it's an R1B zone, but I mean, it's clearly a single family residential neighborhood, except for the portion on the back of it that's not been developed yet, which is still A1. And I think while we have a criteria, we know we're going to have 2 full-time staff working there. There's going to be the one other staff person. There's potentially be nurses coming in, potentially be doctors coming in. They're going to receive, there's going to be supplies brought in and out during the time. These people that are residents there, hopefully they have families and friends that will visit from time to time. And so those people are going to be needing to park in this area. You've got a very small driveway that we want everybody to park in, and if ambulance needs to get in there to get into the facility, or we're going to have to move cars out into the street so the ambulance can get in a hurried fashion. I think you have to, there's more to this than meets the eye, and I think a full-scale development plan would need to be implemented if this moves forward, and it needs to be a condition to consider all those factors, and the state of Kentucky has different kinds of facilities and care facilities. There's besides, there's personal care homes, and they all go to great lengths to define what kind of care can be provided, what you have to have, how many, certain number of lockable doors. Do they all have to have different bathroom facilities? All those things are defined by state agencies, and I think the planning staff, while that they did a decent job of trying to look forward to some of those things, I believe they need to kind of let those people that are in the business of setting up those criterias be involved, or at least change their procedures that they'll meet all the criteria for whatever you're going to call this. It's the application called an assisted living facility. I heard a lot of terms about a nursing home, for which we don't have any definition of it in our ordinance. And then there was a hospital, and certainly we don't think of this as the same kind of hospital as our hospital on Lexington Road, or the old John Grace Ford even. But it was this is, are we going to start to have hospitals in your residential neighborhood, and all that comes with that? I think you need to really consider that closely, and if you do that, you need to make sure that the applicant is held to some stringent standards in terms of what goes on there. How are you going to accommodate all the people that can come and go, besides the long-term care residents that presumably aren't coming and going, but the reason they're there is they need help at facility, and they need people to look after them, and then some of which we've heard tonight, they want other people to come in and take care of those things. They have to have facility, they have to have supplies. These people have friends and neighbors that will visit. How are we going to accommodate all those on a small residential street? It essentially looks like it dead ends right at this property. I think there's some people, other people that resident around the residential area want to speak. So on behalf of my applicants, I urge the Board of Adjustment to deny this application. I like the goal for providing for the elderly. I just don't know that it's appropriate in an R1B neighborhood.
Okay, thank you, sir. Any questions there? Just staff want to clarify anything on, I guess the question there was kind of the due process on how it was originally listed before, how it is now, type of things?
Yeah, so when we noticed for this application, we noticed as an assisted living, a 3-bed assisted living facility / hospital. And that was really with the intent of being true to what the applicant had initially asked for, as well as what it would technically fall under for this to come before the Board of Adjustment for consideration. Regarding the concerns about the development plan, we are recommending that development plan to make sure that all of those things, all of those development standards are met, and that this is appropriate here.
Okay.
If it's not appropriate here, then we will address that accordingly with the development plan. I'll let Holden speak here.
Yep. And again, just to echo what Mr. Smith is pointing out there, in noticing the application as the assisted living facility / hospital, we agree entirely that as an assisted living facility, as defined in the ordinance, this would not be allowed. And so that's really the first half of the staff report is explaining how this is, number one, not an assisted living facility. Number two, shouldn't be allowed as an assisted living facility. Past that, as again Mr. Smith pointed out, we are very much in agreement that this is going to need a development plan. We need to take more time in making sure that the development will not create those unintended consequences to the neighborhood. But staff again is confident that with the appropriate conditions, we can mitigate against those impacts. To the board more broadly, you have a decision to make early on in considering this, which is, do you think that we've appropriately applied hospital as a definition and as a use to tie this use to? That's your first decision. If you don't believe that, then that's the decision right there. It's only if you believe that the use as defined or as presented by the applicant would be a hospital for human care, should you then continue to look for those conditions. If you don't think it's a hospital, it's certainly not an assisted living facility. So I think that the hearing stops there. And so I just want to, explain that, again, through staff's perspective, we've pegged this to the closest use that we have, and then we want to put it before the board to first tell us whether or not you think we got that right, and then if we got that right in calling this a hospital, if there are conditions that could be placed.
Anybody else that wishes to speak? I think we had another. Yep, go right ahead.
So it's my idea.
Could you
and
state your name?
Michelle Buck, been a nurse for 35 years. Probably been in most of these people's homes because I do hospice nursing now. And it was a goal and dream. I go in homes every day and I see families struggle. Like they can't take care of mom. They can't. They don't want to take her to the nursing home. It's sad because some people are equipped and you can teach them and you can educate them, but they just can't do it. It's just not part of their wheelhouse. It breaks their hearts, but it's our job to go in and try to find avenues to help them navigate through the system or either find a place for them. Unfortunately, nursing homes are the last resort. Families say to me daily, well, what am I going to do? I can't do this anymore. Well, you hire caregivers that cost about $12,000 a month, or you send them to the nursing home. This is not like to take up driving space or anything like that, guys. It's to give 4 or 5 families an option to come in to say, I'm going to take care of your mama, and I'm going to do it like it was my mama. And we have staff that are certified. I've been a registered nurse for 35 years. They would still have their own doctors, their own primary care. If they were in hospice, they are overseen by a hospice physician. It's just like living in their home, but they're just living in a different home, getting meals, stimulation, hopefully extended life. It's not to cause any rift. If it is, I'll withdraw the application because I don't want to upset people. I mean, I'm trying to help people. I'm trying to help the community and families that I see in need and that are desiring help. It's sad when you go in these places and there's no option. So it's a dream of mine. My entire life I've been a caregiver. My brother is in with me because we took care of our parents together and we saw the struggle and how real it was. And he's a wonderful caregiver, and if there were men in the home, I wanted a man to be able to be available in case we needed specifics for the male gender. I have females available, and I know the personnel to hire because I've been in this industry for so long. I was a hospital employee for many, many years, and I've dedicated my life to helping others, and I just wanted to do it more, honestly. And so it's more of a care home where you would instill the trust of your loved one to me and my business, and then it's an option other than a nursing home. Because my goal is to see people sitting on the porch drinking coffee and tea and smiling, not in a room where it's dark and dreary and they're so sad they can't look up. Because that's what reality is, guys. I'm just telling you. And it might be your mom or dad that need somebody to help them. That's all I got.
And there was a I think a question that the prior speaker mentioned. What about visitors of the patients?
I mean, it would be families coming, like, you know, and that's one thing I want to address, but also like ambulances that pull up, they don't pull in driveways. They pull in the street and stop. That's what they do. They don't stop in, let me back in here. It's urgent, emergent, and they're not going to just look for a spot to pull into. They're going to stop right in the street and everybody else can go around them. Parking, families, yes, I want their families there.
Okay.
100%. But does that mean they have 20 people? No, not normally. Honestly, there's very few visitors for the elderly. Very few.
Okay. Any other questions for anybody? Applicant? Yes, sir.
I'm the owner of the house, to ask a question about the house.
Okay.
Good.
Yes, thank you.
Well, excuse me, your last name for the record, please?
Buck, B-U-C-K.
Oh, that's what I thought you said. Okay, thank you.
Go right ahead, sir.
You want to look for me this time? Bob Watson. How are you?
How are you?
I think Mr. Sims brought it up. They've changed what this application is. Now they're trying to find it as a hospital. And they're trying to say, and I'm sure we need things for elderly people. But down the road, if we give this variance to them and to make this adjustment so they can do this, what kind of hospital are we going to have down the road there? Are we going to have a hospital down the road for mentally ill, halfway houses for people or stuff? Or is this just a hospice? I don't know. Y'all got a big thing to decide here. And I tell you, there's a lot of people here that do not want this in this residential area. So y'all need to think about what kind of hospital we're really putting there, okay? And as far as the ambulance stopping there at the road, if you look on that map that he showed you, you've got 3 driveways right there together. It's a little bitty. You park any car in that road, you block the other 2 driveways, much less all the staff that's got to be there, visitors got to be there. I don't know that you could get an ambulance to that house if you allowed this to happen. So think about the hospital that you're going to try to get done, and think about that parking there, and the fact you got about 2 rows of people back here that do not want this to happen. Thank you.
Thank you.
I'm Bonnie Sams, and I live 520 Shoshone Trail, right next door to Mr. Parker's house. We bought that house 26 years ago for residential. We've raised kids, grandkids, and we're keeping our great-grandbaby right now. Hopefully, we can continue on in our family and let that be a family residential. My grandkids grew up. You all probably know a lot of the people that grew up over there. McBrayers, the Davilas, the Wallaces. And I'm scared if it comes, I'm gonna walk out my back door and I'm gonna see a parking lot next to me. I've got 5 sisters. My husband's got 8 brothers and sisters. And we have 5 grandkids. So, right now, if you're talking about parking any more cars on holidays, it's a mess. And we didn't buy that resident to be beside a building, a business with blacktop. We wanted to do that, we'd move to Pawnee, where all the other apartments and hospitals and everything is. So I think y'all need to consider, if not everybody, but us that lives next door to it, and the Watsons. It is like a dead end, and then you go into the Watsons Drive. There isn't that much room for all these vehicles. And I don't want the ambulances, I don't want the traffic, and you're right. I've lost a mother and I've lost a father. We'll take care of them. And if not, I'm paying someone right now to take care of my sister that's got Alzheimer's. So, that's all I can say.
Thank you.
Can I address one thing?
Sure, go right ahead.
It would be like myself in 180. We're talking about groups of older people that will probably not have hearing. I mean, it's almost like, it seems like people are thinking that 20 cars are gonna drive in there. They're not. I'm at these homes daily. Every single day I'm at these homes. There's no company that comes. It's very, very few people when you get older that really show up. I'm just being honest. And so the parking, I really don't thought would be an issue. There are other homes around Georgetown that are doing this now. We're just trying to do it the right way. I'm just trying to do it the right way.
I understand, yep. Sir, did you want to go ahead?
My name's George Parker, and I own the property. In the 80s, I bought it for my son, and they lived there and raised 2 kids, and they're grown now, and all this stuff. But in that period of time, from the 80s until, I guess, about 5 years ago, they opened up a daycare center. And at the time, in the 90s, Mr. Watson next door filed suit on him for having a daycare center there. And all this, she had 4 kids or something like that. I'm not sure, she's not here. They got a divorce, but that's another story. But they're not here to talk about it. But they had a daycare there and all this stuff. And I try to talk all the neighbors constantly of any issues and all this stuff like that, to do that, because I live out in the county, out of Newtown, and I thought someday this is a dead-end street. It just one house. I'm the only one on the end of the street. The other house actually faces the other way, but the driveway's on my side. And the farm goes back to the Watsons, all this stuff. So we went to court and zoned this as R1B, I think what it is, and all this stuff like that, and got it approved in the 90s or something like, I'm not sure. Some of these people's here and all this stuff. But my son got a divorce 5 or 6 years ago and left the house. I didn't know what I was going to do with the house and all this stuff, and I retired at Whitaker Bank after 45 years. And I decided just to hang on to it. I owned it all the time. So I decided 5 years ago to turn it into Airbnb. It's listed now in Airbnb, if you're looking on the website, at the Parker's house. It's house 8 people. It's got 4 bedrooms in it, queen-size bed, a large living room, a kitchen, and 2.5 baths. It's been an Airbnb for 3 years. Up to 8 people can be in there, 8 adults. Could have a child or something like that. Of course, I let no dogs come in, all this stuff. And they've been parking there. It's got room for 4 vehicles at this time, an Airbnb site, and they've been parked there. Some of them's got long trailers and trucks parked in front of the house. It's driveway. I'm gonna put some more driveway down and all this stuff. And the side of the house got room for 2 cars and all this stuff. And I was planning on if they gonna rent it and all this stuff from me to put a nursing home there, I would put another drive in the side. So whoever stays there overnight can park there. And if of course, if an ambulance or anybody, any family member wants to come, they can park there close to the house. They could come and go. The house has got 1 step to go in the house. And I was gonna go in there and redo that and put it to no steps in the house. Because Airbnb is one of the agreement. If you got steps, some people can't get in and out wheelchair and all this stuff. I was gonna make it a wheelchair if you don't pass it. And like I told Mr. Sams and all this stuff like that, I talked to Chad, and I told Chad it's gonna be hard to get through because I know some of the neighbors don't like it, and all this stuff. I said, I'm not sure, if you don't get it through, that's fine with me. But I buried 2 family members, parents, and 2 sisters last year, who was 93 years old. One of them in the Georgetown nursing home, the other one stayed at home. Should have been a nursing home, but she didn't want to go to a nursing home that's got 50 or 80 or 100 people in there and all this stuff. And my mother died in 2000, and I'm sad to say, my family members put them in a cheap nursing home, and it was nasty for her for 3 years of life, and I fought for 3 years. But I'm not a fan of nursing home. Chad came to me. I live out in Newtown. I got buffaloes. He brings my hay to me. So he stopped me about 3 months ago, and he said, "You still got your house in Georgetown?" I said, "Yeah, you still renting it?" I said, "It's Airbnb, it's doing pretty good, but I shut it down in the wintertime because nobody's traveling so much in the wintertime, and it might freeze up." So he said, "How about a nursing home there?" And I said, "Do what?" I said, "You know, my sister's a nurse, RN, I'm not sure what she is, all this stuff. She wants someplace where people can come and stay for the last few days of life, maybe last year or two and all this stuff. She don't want some young person come there and stay there and have everything like that. She wants something to, elderly people come there and stay for the life in three-bedroom house for them to stay in. It's a 4-bedroom house. Somebody's going to stay there all the time. So they're going to use 3 bedrooms, and I thought that'd be great. Matter of fact, the neighborhood where I live at is aging neighborhood and all this stuff, like I am. And I said, well, if it goes through, I lease it to you and all this stuff for a year. If it don't go through, I leave it Airbnb. It's okay. It's not affecting me one bit and all this stuff. But as of now, if you go on Airbnb, look up Parker's house, it does have room for 4 cars parking and up to 8 people stand there. And the house is, it's all finished, all furnished now, but she's gonna take a lot of the furnished out, she said, and all this stuff, and put in lift chairs and beds and all this stuff. But I said, whatever. So I'm here, if you approve it, if you don't approve it, either way, it's okay with me. And I don't want to get none of my neighbors mad at me because I still got to live there. And whatever you decide to do, and my Chad lives right behind me, so I hope he keep on bringing me hay and all this stuff, or whatever. But whatever you decide to do, I hope y'all have a good day, and thank you.
Thank you so much.
I do have one question.
Go ahead.
So it started out as an Airbnb, they wanted to do, not Airbnb, you got me Airbnb in now, but they started out wanting to be assisted living, and then it changed over to hospital. So is there a set definition for hospital? Because I would think hospital would require a doctor to be on site since it was going to be a hospital.
Great question. So in my limited conversation that I've had with the applicants, I'll just say the vision that they presented and what they want to do on the property has remained consistent the entire time. It's exactly what was just described to us by the property owner. And it's really what staff's intent was to review for, is the use as it's actually going to impact the neighborhood. This question of what we're calling it, I think is really, it's important that we get what we call it right. But I also don't think it's quite fair to expect the applicant to know all of our definitions and all of our terms that we utilize. So assisted living facilities are defined in our ordinance. And in that definition, they don't include nursing care.
Right.
It's primarily the residential aspect. We do not define either hospital or nursing home. Rather, instead, in our comprehensive plan, we talk about the need for these different types of options. And so that's why Mr. Smith went through and talked about that common usage of the term. And so, yeah, most hospitals have doctors. We've conditioned that if medication is being administered, it needs to either be a doctor or a registered nurse who can legally do that. Mr. Sims had talked about all the state statutes that this particular use would have to obey. Well, we can condition that as well. We don't want to do anything that, number one, would allow them to somehow think that they are stepped outside of the state requirements or stepped outside of our requirements. It's just a question of, can this use as a hospital fit into this neighborhood with conditions? And so that's where, again, staff says yes, again, understanding that there's a lot more conversation I think that we're going to have here tonight.
Yeah.
That's
Any other comments or questions from the board, or what y'all are thinking?
I'd say what I'm thinking is, what are we exactly voting for?
That's what I'm saying, I don't know.
Because if we're just gonna vote on the terminology and we have no development plan, I know I can't in good confidence approve something with no development plan.
Well, again, typical process, you wouldn't have a development plan until the use is allowed.
Right.
And so you can't get a development plan unless this board acts first to grant that conditional use permit.
Right.
Without the conditional use permit, the development plan won't exist.
Right.
That's where the condition indicating that they would have to meet all of our development regulations is assumed. The use doesn't happen unless they meet those further requirements. The question is just, does this use conditionally apply to this zone?
Right. Is that never changeable?
No.
No,
No.
yeah, that's kind of.
Kind of puts us at an
Yeah.
unfair advantage.
You guys get first crack at it.
Yeah, that's
Yeah.
true.
Yeah.
Go
If
ahead.
a
go ahead.
development plan is
Yeah.
produced, be it minor or major, like we were talking, who does it go to for approval? To the staff or to the board?
Yeah, so anytime that a variance is requested, it's gonna go to the board, or I'm sorry, excuse me, the planning commission. And so, you know, we went through all of those requirements for the A1 zone, we went through all the requirements for parking and these things. If the applicant can meet all of our regulations, staff reviews it ministerially. If there's any regulation they do not believe that they can meet or that they should have to meet, it then goes to the planning commission. Would you like to condition that this development plan only go to the planning commission? I think that would be within this board's purview. We'd pretend. I'll look to Charlie on that one.
Well, technically, no, I don't think they can do that.
I don't think you
Unless there is an issue, that requires, some sort of specific review, and I think they need to state a reason. Otherwise, I think this is a ministerial, action.
Without variance.
Well, not the approval in general, but the development plan itself.
Anyone else? Questions or comments?
I just want to, I think, I want to stress my main comment, or my main concern is that we switched from an assisted living facility to a hospital for human care, and I think that opens the door for more than just this type of facility. I think you're opening the door for applications that aren't before you yet, but this has paved the way. I see in my practice, I see people all the time, that they leave Eastern State, and Eastern State puts them in literally puts them in a ride share, and they go to the Hope Center. There's no place to go when a lot of people, when they leave that facility. So is somebody going to try to start a hospital for human care that's taking care of mental patients, and they use this as application to go down that road? I think the goal for providing care for our elderly in this community is a noble goal, and I'd like to see it happen. I don't know that pigeonholing this application to achieve those means is a good idea.
Okay, thank you. If there's no other comments, does anybody have a motion that they'd like to make on this?
I'll make a motion, but I don't know if I'll get a second.
Go ahead, let's hear what you got.
I make a motion that we deny the application because it was changed.
Well, I have written down here uncertainty on verbiage, for whatever that's worth, so.
And like,
Go ahead.
well, just like, Mr. Sims said, it kind of is gonna open the door if we leave it like it is with the verbiage as it is. It kind of leaves it open. So,
And I mean, I'll also say, on top of that, I know the work is golden. I know it is. It's beautiful stuff. It's not anything on that, but even with 3 patients, with the employees on site and the families, I do think it's a drastic change to that area with the parking and the 3 development standards for the no climb boundary fence, the minimum setbacks, landscape buffers. It's kind of a drastic change there too. So if you want to include that in your motion, I just wanted to let you know what I was thinking as well.
Can you word that?
Yeah, if you all stay for another hour, I can word that. But no, I do agree. I think you need to incorporate that into the motion in that way. But now let me see if I can corral the motion. First off, you said to deny because basically the nature of it was changed between the application and
And what was
notification.
presented, and what was presented.
And the hearing. So let me write that first, and then we'll move to the next point. Okay, so it was changed in nature between the application, the notice, and the hearing. Now, Mr. Chairman, the points you were raising, please. Oh, that it would change the nature of the neighborhood.
Yes, I just think it's a drastic change to this area because of the development standards that are going to need to eventually be a part of it.
All right, when you say it changed, can we make that an impact to the neighborhood?
Yeah, for sure, sorry. Yeah, absolutely.
All right, and I'm gonna ask you to repeat again, due to what?
Due to.
The impact due to,
Condition number 11 having an impact.
Basically, the comprehensive plan or the development standard that's going to follow.
and that would be the fencing, parking,
The three that are listed are the fencing, there's a minimum setback, a landscape buffer, and then, yes, there's a plan for parking, expansion.
all right, all that's fine, but would you also include in that then just the impact of parking, and traffic in general?
Yes, like I said, even with the 3 patients at one time, there's going to be 4 employees possible and families. So we're talking about, a pretty good amount for that area. But, yeah, if you want to read it back for Jenny, since she's making the motion.
And it would be a drastic impact on the neighborhood due to the development standards that would follow, fencing, parking, setbacks, buffering, and the traffic, employees, and families visiting.
Yes.
Yes.
Anything else? Hope I can read this when I get back.
I do have a question for staff. Is there any zoning or anything we're looking at for something like this to be actually, instead of us trying to find a substitute as hospital as a name for it and give it some other kind of name, I think?
Yeah, so as a conditional use in all zones, hospitals are really taken as a case-by-case basis.
Okay.
So the existing hospitals we have, if somebody wanted to come in exactly like that, we would be analyzing again for the impacts that it's going to have. Right now, staff doesn't have any, we have not proposed any changes related to assisted living facilities, nursing homes, or hospitals.
No, but the professional office doesn't allow by right. We can worry about it.
Okay. Yeah, so professional office is a rarely utilized zone that we do have.
Yeah.
It allows them by right. Again, meeting all development requirements.
Yeah, because it's a great idea. I mean, you know
Exactly,
what I'm saying?
yeah.
it's a
If it could
really
just
great
be
Yeah,
a
we
little
just need to
more.
find another zoning thing, another
Right.
zoning application for the assisted living, where we can put it in. Because that's what she wants to do, is assisted living. She doesn't want to do a nursing home, right?
No, she wants
No,
to
she
do the
wants the
nursing home.
nursing. They
That's-
want the nursing to be part of it.
And again,
Okay.
just to
Yeah.
clarify.
That's why it had to change.
And I've got to support my staff here one last
Right.
time. From application through this decision.
Right.
The application or the nature of has not changed.
Okay.
They've been very consistent with what they want to do. The only thing that has changed is staff told them that what they're proposing is not assisted living.
Right.
Right.
What they're proposing would be a hospital.
And I hope this could be.
And we noticed as assisted living /
Right.
hospital.
Yeah, and I hope this could be used as an example going forward, because like I said,
That's what I'm saying.
I definitely think it's a need, it's a big deal, and it's good work, but I mean, I do think maybe some clarity on
Yeah.
the next comprehensive plan or anything would be beneficial. I really do. All right, Jenny, listen up.
What's it say? So,
You want me to read this thing again?
You've read way longer.
All right. Oh, that's right, we didn't even have a second yet, do we?
No.
All right. Motion by Virginia to deny because it was changed in nature, although we understand there's a distinction there to be made, not in nature of what the application was, but in its description. All right, where am I? Hold on. Between application, notice, and hearing. And it would be a drastic impact on the neighborhood due to the development standards following any approval, such as fencing, parking, setbacks, buffering. Also, the traffic generated by employees, families. I think it was mentioned in somewhere in all of this, even the deliveries and emergency vehicles and other things.
Sure.
For that reason, deny.
You all right with that, Jenny?
Mm-hmm.
Would anybody like to second?
I'll do it.
Jeremy, second. All those in favor? Aye.
Aye.
Any opposed? Okay, motion passes as presented. Thank you all. Okay, on to E. Is that right? Is it E?
All right, last application of the night, G 2026-12, conditional use permit for a home occupation. Take 5?
Yeah. Thank you, guys. Yeah, we got you.
Yeah.
We'll just take a minute, so there's no background noise. If you could make sure you exit and try to keep as quiet as you can. Thank you. Yes, sir. Oh, are they not up there? Are they not? Oh, okay, I got you. Yeah, I got you. Thank you. Okay, thank you, guys. I think we're okay to go on to the final application of the night.
Look at me.
Huh?
I said, don't look at me.
Why not? Step up there. Come on.
No, I'm getting rusty. I need to start presenting again.
It's okay. It's okay. Take your time, bud.
Yeah, you're fine.
When, yeah.
We did. It was a fast five.
I'm sorry. I meant just take a minute. But if you need to, no, bathroom or something, go ahead. We're ready if you're ready.
Yeah, we're close to the end now.
Yep.
so.
Go ahead.
Last application of the night, G 2026-12. We've got a conditional use permit for a home occupation for a federal firearms licensed business. The location is 112 Bill Perkins Lane. The zone is R1C PUD. Surrounding zones are R1C, R3, R2, and B4. The lot size is 0.21 acres.
Excuse me 1 second.
That's the wrong address.
Oh.
122.
That's what I have on mine too.
What, 123?
So on
122.
We got one.
Yeah. On mine I have 122 Bill Perkins Lane. Is that correct? So just noted for the record, and Charlie, on the screen it says 112, but our packets do have the correct address.
Yeah, I never read the screen anyway.
You gotta look at the screen sometimes. So just for note, the correct address, 122 Bill Perkins Lane. Thank you.
I apologize for that.
That's okay. Go right ahead.
Direct access is from Bill Perkins Lane. Arterial access is from McClellan Circle. And staff does recommend approval on this application. Seen here is the aerial view of the proposed site at 122. Seen here is the zoning map. So regarding the scope and details of the home occupation, it is a conditional use permit for the operation of a Type 1 FFL business as a home occupation. The business will offer in-person services by appointment only and online retail services. There will be no open storefront aspect. As indicated by the applicant, the business will be conducted online or with that in-person option by appointment only. And there are no previous BOA applications on file for the project site. So regarding home occupations, the zoning ordinance does list home occupations as a conditional use permit in the R1C zone. And it does require the following 3 things for any home occupation. It requires that the home occupation be incidental to the primary residential use of the property. It requires that there be no exterior evidence of the home business outside of a small wall sign not to exceed 5 square feet. And it requires that it does not generate any atmospheric pollution like flashes, glare, odor, noise, vibration, truck, or any other heavy traffic. So the proposed business should have minimal, if any, impact on neighboring property owners because that open storefront, there is no open storefront aspect, and because that in-person business will only be conducted through appointments. The applicant is not proposing any changes to the exterior of the property at this time. They may elect to do that wall sign, but they have not indicated that up to this point. The applicant intends for that online and by appointment in-person option, and that will minimize any traffic coming to the project site. Staff does recommend a condition of approval that parking arising from those in-person appointments must be off-street so that we do not have those disturbances to the surrounding area. The proposed business should have no impact on adjacent property owners. The driveway would be large enough to accommodate off-street parking for those appointment retail services. It would not generate any noise, odor, light flashes, glares, or any other nuisance, and it would not adversely impact the public health, safety, or welfare. Would not alter the character of the general vicinity. So something to note here as we consider this, KRS, Kentucky State Statute 65870, does make the provision that no existing or future city, county, urban city government, charter county, et cetera, or any person acting under the authority of any of those organizations may occupy any part of the field of regulation of the manufacture, sale, purchase, taxation, transfer, ownership, possession, carrying, storage, or transportation of firearms, ammunitions, components of firearms, components of ammunitions, firearms, accessories, or combination thereof. So under state statute, we cannot discriminate based on the fact that this will be operating as an FFL licensed business. And safety-related provisions pertaining to that firearm element of this use will be overseen by the ATF and the federal, the FFLC. So for some context, we have the different federal firearms licenses here. In total, there are 11. And the proposed license that this home occupation will be operating under will be Type 1, which is a dealer in firearms other than destructive devices. So where that differs from the other items listed there is they will not be making guns on site. They will not be manufacturing anything on site. And that other than destructive devices is important because it is more typical, firearms that are smaller in nature or more sporting and are not as destructive as defined by the ATF. So under the nature of the license type, those weapons are not going to be manufactured on site. And staff does note that this application cannot be treated differently than any other home occupation under state law, KRS 65870. And one other thing to note is should the applicant receive approval for the conditional use, they will take this information to the ATF for further consideration, and the applicant may speak further to that. So findings, the project site is a 0.21 acre property zoned R1 CPUD. The application is for a conditional use permit for a home occupation. The zoning ordinance does list home occupations as a conditional use in this zoning district. Federal entities such as the ATF or the FFLC will oversee safety-related issues pertaining to the nature of this specific use. KRS Chapter 237 also does create some state-specific standards pertaining to this use that must be met. Approval of the conditional use would not adversely impact the public health, safety, or welfare, and it would not alter the character of the general vicinity. The proposed use is protected to a certain extent under federal law and the Second Amendment. There will be no exterior evidence of the home occupation, and traffic to the site will be minimal because that in-person business will be limited to appointment only as indicated by the applicant. So recommendation, staff does recommend approval of the federal firearms license home occupation business at 122 Bill Perkins Lane. And we have our typical standard conditions. And then starting at 6, we have our unique conditions for this use. All parking arising from in-person appointments must be off-street. There shall be no exterior evidence of the home business outside of the small wall sign, which is what is typically allowed for home occupations. In-person business shall be by appointment only as indicated by the applicant. The applicant shall not begin the conduct of business until appropriate licenses and permits are issued by the ATF or FFLC. The applicant must comply with all standards and requirements of the FFLC, ATF, and any applicable federal or state firearm laws. Applicant must comply with KRS Chapter 237. And lastly, should the nature of the FFLC license change from anything other than Type 1 dealer in firearms other than destructive devices, which would therefore change the nature and scale of this home occupation, the applicant must return to the board for reconsideration.
And can you go back one slide?
Yeah.
Yeah, okay. Again, just to note, the address is 122 Bill Perkins Lane. On that one, it looks like it's 32.
Yes, it is 122. I
Okay,
apologize.
yep, just wanted to make sure on that. Come on, Holden, I'm just keeping it in check. I'm just keeping it in check. Anything else on that? Was that it?
Yeah,
Okay.
that's everything. Does the board
Do you have any
questions?
questions for staff?
I don't know if I can ask a question because it's about firearms. What meets a qualification of a destructive device?
So, as I researched it for this application, the other thing to kind of note is the applicant may understand this a lot better than I do. But is the applicant here?
Yeah, over there.
Would you mind?
Grenades or incendiary devices,
If you wanna-
explosives like that.
Yep, okay. And we'll make sure you get up here to speak on that as well. Any other questions for staff? We'll probably ask the applicant that. You can go right ahead. I think we're ready to go.
Thank you.
Yep, thank you. And did you sign in,
Yes,
swear
I
in?
did.
Okay,
Co
and just
Norton.
state your name. Yep, thank
Co
you.
Norton. Yeah, so as it says, this is a type 1, so it does not include like explosive grenades or anything like that. It does allow you to sell ammunition, just like you could buy at the local sporting goods store. It would be for, small firearms and sporting firearms like that. It's not going to change the composition of the area. All packages, because I know some people might be worried about there just being a stack of guns sitting on the front porch. I have to sign for those in person. You can't, with the FFL through ATF, you have to sign for the weapons and automatically receive those into a bound book, which is a software that registers all the transactions of the firearms coming in and out. Even if it is online, you still have to transact that in the bound book the same as if it was in a store or in person. So,
But those would be drop shipped.
yes, correct. It would not come to me. They would leave from the distributor and go straight to an FFL location, and then that person would sign and fill out the background check there. That's the other thing. Any in-person appointments would have to complete a federal background check, the same as if they did at any other gun store before scheduling the appointment, because you can do that digitally.
And I had a question on that. Do you have any idea on anticipated numbers for an in-person by appointment only for a year?
A year, maybe 10 or 12.
Okay, just
I mean,
curiosity.
it's not gonna be very
Yeah.
much. This does allow me to do like engraving on non-serialized parts, like a slide of a pistol. So that allows, if I was to take something in to personalize, say for a friend who's deploying for a commemorative piece for a deployment, I would still have to have an FFL to take that firearm, to engrave on it, to then give it back to them, and they have to have the background check and everything else like that to complete that as well.
And
So,
and you have the ability to provide for the off-street parking?
yes,
if there
I can
was-
park 4 vehicles in my,
Okay.
in my driveway, and I only have 2
Okay.
that are permanent. Yeah, and like I said, all transactions require the ATF background check, NCIS, or NICS check. You know, there's, this is the same as if I wanted to do crafts or T-shirt business. I wouldn't have to get a conditional use, but because it is firearms, I have to get a conditional use permit. But, you know, I'm not gonna have any more people than, say, if you're selling stuff on Facebook Marketplace that come by and do porch pickups. You can't do that with a firearm. You can't just have people drive by, go pick stuff up, and then leave. It has to be a by appointment only. I have kids and a wife, and I don't want random people in my house. So if I don't know who you are and you don't pass a background check, I'm not giving you my address. It's just not happening. And my wife will not let that happen either. So, are there any other questions at this time?
Yeah, it said there's not gonna be a storefront, but
No.
what about storage?
I have the required storage that ATF will come validate is acceptable before they approve the application, but I have to have this conditional use permit to go with that application for them to approve it, and they will do an in-person inspection and stuff like that.
All right.
How is black powder classified?
Black powder is classified as ammunition, but the firearm is not classified, depending on the age, as requirements to be an FFL transfer. If it's an older relic, they consider that it's a different type of FFL that you can have to do a black powder rifle if it's old enough.
Because I know there's some restrictions on shipping of black powder, so.
Correct. I will not do black powder stuff.
And just to clarify, I do think, you mentioned something, staff can help me on this. I do think if you had a craft business,
Yeah.
T-shirt, you would still technically need a conditional use permit.
Okay.
You would still need that.
Well, if that's
yeah.
the case, there's plenty of people in our neighborhood that don't have those.
We won't get into that. I'm just saying, you know, you're supposed to, even if it's,
Yeah.
if it's bracelets or a T-shirt, you're still supposed to, so yeah.
Right.
I think, just to clarify on that.
Okay. Anything else at this time?
I think we're good. Thank you.
Thank you.
Anybody else that wishes to speak, either for or against? You guys want to decide?
Yeah.
Everybody's
I'll go for it.
everybody's been sworn in.
Yes.
Okay, make sure you state your name.
Do we need to sign?
Oh, yeah.
Yes, there should be a, yes, sign-in sheet there, and then did Charlie swear you in at the beginning?
Yeah.
Okay.
So my question is, look, I don't think there's
What was your
a-
name?
Adam McDonald.
Okay. Go right
Maybe
ahead.
Adam,
Adam McDonald,
Oh.
like the hamburger place.
thank you.
And then, I guess my question is just knowing what the standards are from the ATF. I think you're gonna have, there's a lot of people who are gonna have questions about understanding what you're doing, I'm sure, that are here. And fair enough, right? There's a school close by. There's also, which I'm surprised that wasn't why it popped up as an issue. But there's a school close by, and then you're in a residential neighborhood. It doesn't look by the law that there's anything we can do. But also, my question is just clarity on the security. Like, if somebody were to break in, like, what's the accessibility of firearms?
It's no different than it is right now with my personal firearms. You have to have a combination code and a key to get into the vaults.
Okay.
So you cannot have them easily accessible. They have to be behind a code and a lock and key.
And that's a requirement on your own or just by?
By ATF.
By ATF, fair enough. Second question, and then I'll leave it to everybody else, is does it present any difference depending on what you have for the fire department? If there were to be a fire with the ammunition and at the house?
I have ammunition in my house now, so I mean, it shouldn't change.
I didn't know if it changed anything.
No, I had to notify the city police department though of this.
Okay, so
application.
fair enough, they would know like
They
what
know
they're
there
getting
is an
into.
applicant at that location, the city police department does know that.
Okay,
It is a requirement of the ATF application that you notify the chief of police or the sheriff if you're in the county.
because I know sometimes it's helpful for them to know. what
Yeah,
they're
yeah,
hopping
so
into if there's a
I had to
fire.
go get fingerprinted and everything like that for federal background check. And, you know, being a retired military guy, I got a clean background, served my country honorably, retired and everything like that. So, just going by the law of federal regulations and everything like that, everything will be stored appropriately. And as I previously stated, they will come to an inspection,
Before,
before
yeah.
but ATF will do an interview and an inspection before they approve it, but I have to get approval from this board for that application.
Before their approval.
Yes.
Fair enough. Thanks, boss.
Yeah, thank you. And I'll make sure I know I was supposed to do this before, but I apologize. If there's any questions, I'll try to jot them down and get you back up to the podium at the microphone, so I apologize about that, but thank
Okay.
you.
My name is Lisa Brantley, and I live directly behind him. Our backyards butt up with each other. I'm at 187 Ruth Miller. Everything down here.
And you said you were sworn in, correct?
Pardon?
Sworn in with Charlie at the start?
No, I haven't been sworn in.
Oh.
See, I'm good thing I checked.
Do you swear or affirm? I thought you did. I'm sorry.
That's
No,
okay.
they came in later.
Do you swear or affirm?
I swear, everything, and I really do swear, and I might say a couple swear words while I'm doing this. I
Yeah, that's
swear
all
to
right, too.
tell the
That doesn't change the
truth
tenor
and nothing
too
but
much.
the truth.
Thank you.
Okay.
Thanks, Charlie. Go right ahead.
It does not bother me if people have guns, whatever, in their home. Everybody has their own opinion. I don't believe in having them. I have lived here in Georgetown for 38 years. I have a husband that I've been with for over 40. 3 years ago, I lost my husband. He had been very sick. He was very sick for a long time. I know he was in a lot of pain. And he had a 50-year-old or older childhood hunting rifle that had went from one closet to another closet to another closet. I woke up one morning and he had went into the garage and he had shot himself in the head. That doesn't have anything to do with everybody else's opinion. My opinion is, I don't like them. I have met my neighbor right here at the end when I moved into this house just a little over 2 years ago. I downsized after that happened with my husband. God put me in the best neighborhood. I've got the sweetest, kindest neighbors. I was in my backyard and I stepped up on the electrical box and I introduced myself to him and his wife and to the other neighbors next door. Have not spoke to him since. But honey, everybody else in the neighborhood knows me very well. I'm very outgoing. I love kids. We do live very close to an elementary school. My kids, my grandkids are grown, but I still love watching the little ones. I got a letter just recently. I think it was mailed to me, but I was gone for a week. I got home Friday night, got my mail. Inside my mail was a letter saying that he has applied for this. When I read it, it scared me to death. I'm backed up to a guy that's going to be selling firearms. They're going to be coming to his house. They're going to be getting, I'm like, that's what stores are for. You go to the store. You go to places. You don't go to a neighborhood where there's kids riding their little bikes, where they're out, you know. I have nothing against people that have them. You put them in a safe. You make sure that your kids can't get to them, you know. But no, I don't think it's right to have something like this in your neighborhood, and I especially don't think it's right to have something that backs up to my backyard. And if it does get approved, I probably will. Living here as long as I have, I will move out of Georgetown because I don't think that that's right. There's a place for you to go to buy a gun, to buy ammunition. not in my neighborhood. I'm sorry.
It's okay. Thank you.
I need to be sworn in with you, Charlie.
And your name, please?
It's Jeffrey Humble.
Jeffrey?
Jeffrey Humble.
Okay, and do you swear affirm?
Yes, I
swear
swear.
affirm.
I swear and affirm. My name is Jeffrey Humble. I am the representative from the Fox Run Advisory Board. We are a volunteer board that was put together because we're still kind of a new neighborhood, part of Phase 1, Phase 2, and I think Phase 3. So the developer asked me to come and speak on this matter along with 7 other people that I have proxy for in the neighborhood that are against the application that we received showing where this was requested. Being on the board, we approve a lot of different things. Mainly fences have been pretty contentious here lately. We had a fence that was just the post and a bunch of chicken wire, and it didn't have those 2 extra boards. So we had to fight that and take care of it and make sure that it was remedied based on the declaration and covenants that is filed with Georgetown. It was filed April 8th of 2020 here in the county. And it's had a couple amendments since then, but obviously we've not had any amendments that would ever approve a home occupation or a business. Now, you know, you can buy your cupcakes from Mabel down the street. Myself, I would rather go to Whole Foods and Kroger because I can control the ingredients in that and I know what I'm doing. I'm also a gun owner. I have several guns in my home. I have several guns on the farm that I used to own. I brought a lot of those back home with me. They're in safes. I inherited a lot of guns that I don't even know how the hell to shoot. So I have a lot of guns myself. So this has nothing to do with a political statement of someone having a gun. This has to deal with safety. I don't know if I said this, I share a corner with this individual. I've never talked to him in my entire life. I've seen text messages from other people that have showed that he thinks that I'm a failed politician and that he wants to punch me in the face. So I've never met him. Lisa did at least try to get to know him, but you know, that's neither here nor there. Based on the findings of the advisory board, we do not, like I said, approve this at all based on our covenants. It plainly says on page 16 of the covenants, section 14, that's filed with Scott County, there's no trade or businesses of any kind. This individual that filled out this application also had several complaints that he put through as anonymous, where he had a complaint with a handicap business that was down the street because of parking. If that was such an issue with parking, then how is his business not going to be an issue with parking? I realize it's by appointment, but 2 wrongs here don't make a right. You can gripe about one thing, and then you find another thing that you just want to get by with. That's not how that works. I really would hope that you guys would consider that, you know, we've already turned this over to our attorney that takes care of the HOA, and we will be seeking further matters to see how we can obviously remedy this if this goes forward with this board. But other than that, that's all I had to say on behalf of the board and the 6 or 7 people that could not be here tonight, along with myself and my neighbor.
Thank you.
I do have one more thing.
Sure, go right ahead.
I did get a letter,
Go
and
ahead.
I was talking to some of my neighbors.
Up to the mic. Yep, go right
I
ahead.
did get a letter, and I was talking to some of my neighbors, and there was only a few, like a circle, that got the letter. So I made copies, and I was going around the neighborhood and letting people, did you get this letter? No, they didn't get it. It was not mailed to them.
The letter from the,
Showing what he was asking and that what was going to be going on here today.
what's the radius on that again? 100 feet? Yeah, it should have been, I mean, you'd have to ask them about that, but it should have been mailed to.
So when I found out that
radius.
the majority of the neighborhood did not know anything about this, I made copies of the letter. And today, I was personally just going and just saying, I just want you to know this was going on today, at the courthouse. And he's seen me do it. And I have witnesses. He wanted to discuss it, and I said, no, we'll discuss it at the courthouse. You know, I've been here for 2.5 years. You ain't said nothing to me yet. No, we'll discuss it. And he was an asshole.
Okay,
So,
let's.
and I still
all right.
have to live beside.
I appreciate your opinion, but please with the profanity, if you
Just
keep
one more
it
thing,
out,
too.
I appreciate it.
The thing about the letter, I don't know if it was this individual I talked with or someone on the phone today in this office. There was an open records request that we could have done had we have known that would have been something available to us, and we did not do that. Having more information, and, you know, everyone did not get the letter, so that's why we had to do as few proxies as we could. At the end of the day, like I said, we're not trying to keep anybody from having a business in the neighborhood, but they need to go through the correct channels. And so once again, the attorney with our HOA would just have really appreciated the heads up, and so would the developer. This was all news to us, and like I said, we didn't receive any type of notification.
I got a question for you, sir.
Yeah.
So you said the advisory board hasn't been around for a long time?
I'd have to look back at the Facebook and see when we were actually, I guess you could say, appointed.
Right.
It was a volunteer group. Everybody in the neighborhood had the same letter that was sent out. They had the same
Right.
communication. They had the same messaging.
Right.
It's not my fault that Joe Bob over here and Joe didn't sign up to be that. They didn't volunteer.
Yeah. That's not my question, though. My question is, if you are HOA, was he provided use restrictions? Like what he can and can't do?
Everybody,
when he bought the place.
in the neighborhood, yes. People can sit there
Okay.
all day and say they were not provided
Right.
those deed and restrictions, but it's filed with the court, it's filed with your deed. You can go
Right.
down to the office, I think it's in this building. You can go and get that in the office.
Okay, thank you for
So our
clarifying.
attorney will follow up with you if he needs to.
And so, it's come up before, we'll bring it up again. We don't enforce HOA restrictions. That's a private contract between the homeowners
Right.
and their HOA. However, if I'm looking at the right HOA restriction here, it does say that no trade or business of any kind, except for home occupations expressly permitted by applicable zoning ordinances that do not alter the residential character of the subdivision. You guys are making that determination right now.
Right, and that's the focus of our purview, and I appreciate everybody's comments. I want to make sure everybody gets a chance to speak, but, you know, that's what we're focusing on. I know there's other things with regards to the HOA, to the federal things, but that's kind of separate from what we're trying to decide here.
And then just to clarify too, so that 100-foot radius was 15 properties.
Okay. And no notification had to go to anybody else, right? I mean, the developer, right. It's just that radius, yep. Thank you. Yep, go right ahead, sir.
15 property.
You know, I'd just like to mention that, as he stated, there are other businesses in the neighborhood. There are other businesses that do impede the traffic flow of the neighborhood. And as I stated, this will be appointment only, and parking will be in my driveway, not in the street for this business, if somebody does come. But there are commercial vehicles that are parked on the street that are not allowed by the covenants either. So I just don't want this to be a tit for tat, but if we're allowing some people to have commercial businesses with commercial vehicles in the driveway and in the street, then I should be allowed to have a private vehicle in a private driveway by appointment only. That's not there every single day and every single night.
Thank you. Go right ahead.
Yeah, all right, I'll make this quick, guys.
And
I
you're
know it's
sworn
getting late.
in, sign in?
I have sworn in. I
Okay.
will sign in now.
And if you could just state your name before speaking?
Yes, sir. My name is Amanda Jefferson, and I live in the same neighborhood as the applicant. I have a 7-year-old, a 4-year-old, and a 1-year-old, and I live on Pleasant View Drive, so just catty corner to the street that he lives on, and I can see his backyard. We often walk down his street every day, pretty much, if the weather is pleasant, which it has been lately. So we are out and about. I'm an engineer at Toyota. I used to be on the board for the Scott County Humane Society, so I'm very invested in our community. I am here. I love our neighborhood. I want to keep it safe, and I want to keep it the way it is. So I just have a few comments that I want to make. As you guys are aware, an FFL business inherently is going to involve third-party transactions. It's going to involve shipments and customer pickups. That is not residential use. Our neighborhood is designed for low residential traffic, not business-related visits from unknown individuals throughout the day, and as that conditional use permit is currently written, also at night. Even this small FFL will generate customer pickups, package deliveries, and potential increased unknown visitors to our already congested neighborhood. The backside of this area is still under construction, and we have to deal with concrete trucks. We have to deal with construction teams, painting vans, you name it, we have to deal with it coming in and out of our neighborhood. Adding a business with even a small traffic footprint will not help with this situation. With this pending construction, not all of the sidewalks are constructed, including this street. I am regularly walking my 7, 4, and 1-year-old and have to maneuver us onto the road and then back onto the sidewalk when we go for a walk. Our kids play in this neighborhood. I'm ensuring my kids should stay out of the roads, and it's up to Scott County to be responsible for limiting business use to properly zoned areas and not residential. If this home is a 2-car household, and he's talked about this a little bit, unless they park in the garage, there is not enough space for patrons to park off-street, and definitely not enough space for more than 2 cars without blocking sidewalks. However, my biggest concern is that there are no enforceable limits on this conditional use permit. There's nothing proposed that ensures this remains low impact to our neighborhood. Without clear conditions, this could evolve into a much more intensive use. For example, what are the hours of operation? How many appointments per day? Which that was touched on, not many a year, and I appreciate that. How are records and inventory stored? How much inventory is allowed on site? What prevents this from expanding? What prevents walk-ins? How will traffic be tracked and limited? If approved, this sets a precedent for other commercial activities in residential zones, eroding the integrity of zoning protections for homeowners. As a member of this community, I respectfully ask the board to deny this conditional use permit. Thank you.
Thank you. Is there anything in the conditional use permit about the times she mentioned at night?
Yeah.
I don't know if I knew that.
I don't think there is.
I looked, I didn't see any.
I didn't see it.
Yeah, so obviously, the applicant has stated that his plan is to have a majority of his business conducted online. So there's
Right.
no reason to limit his e-commerce side of this. However, if we are setting appointments, understanding the state law, there's nothing that would prohibit this board from limiting the hours of operation as far as the appointments are concerned. And so in that case, and I'll let the applicant speak to it, I believe that feasible time restrictions would apply here.
Is there anything in the conditional use permit in general? There's not?
No,
Okay.
no, but, I mean, pick some hours.
Okay.
Yes, you can
Yeah,
apply those as one of the
There's a
conditions.
condition.
because we'd apply it to any home occupation.
Okay.
Like any,
Yeah, right.
like any home occupation, yeah.
I'm sorry, you have to come back here. They're keeping me on my toes. Could you answer the hours of operation you might for those?
Yeah, so as I stated,
Marginal
I have
walk-in.
3 small kids too. So my hours are gonna be between like 8 and 5 or 6, no later than that, because I have kids that need to get ready for school, go to bed, have sporting events, have educational activities, those types of things. Again, this is by appointment only, so
Right.
if my kid has an activity, I'm obviously not gonna just be running people in and out while I'm trying to do that. I'm on the school-based decision-making committee at Collins Lane in Frankfurt, where my kids go to school, because we're a split family, so I'm heavily involved in the community. I coach soccer here, so I'm not planning on having high foot traffic or industrial commerce and all that type of stuff.
Right.
It'll be less impact, and family gatherings, I can have 4 vehicles in my driveway.
Okay.
And it's no different than the rest of the neighborhood where people have to venture into the road to walk around because the sidewalk is not there or impeded by construction equipment. So, as I see it, this is not gonna change the course of very much. It'll be an extra vehicle. And as I stated, there are commercial vehicles parked in driveways and on the road just up the street from me, close to some of these folks that are here talking today.
On your by appointments, do you think 8 a.m. to 6 p.m. is
Yes, sir, that would be.
more than feasible
Yes, sir,
on hours? Okay.
yeah.
Monday through Friday.
Oh, thank you.
Yeah, I mean, I would like to have weekends just because, you know, some people do work those hours. And if somebody works a Monday through Friday, say like I do in Louisville, and I can't get back till 6, you know, I'm changing employers, so that's going to change. But say somebody does work out of town and they can't get back, so they want to schedule a Saturday at 10 a.m., I would like to be able to do so. And if Sunday's out of question because of church traffic, that's totally cool. But I would like to be able to do Saturdays.
Okay.
How would that impact your deliveries where you have to be home to sign for these?
I have to schedule those with the deliveries, if any deliveries come, but where majority of this business is going to be e-commerce, it's drop shipped from the manufacturer or from the distributor straight to an FFL, somebody else in a different area. So if I was to receive something, say you wanted to purchase a firearm, and I purchased it and brought it in, you do the background check, you would then schedule a time with me to come in. I would sign for the package in a scheduling app with UPS, FedEx, et cetera. You can set those to arrive
So
at a
you can
certain
restrict
date and
those to
time.
that, you can
So-
restrict those to that time period?
Exactly. Yeah, you could restrict those to that time period and to certain days.
Okay, thank you.
Yes.
Charlie, is there any issue with a Monday through Saturday time on this?
No, the main thing we have to keep in mind, and I certainly understand the various concerns, but both the state law that Noah referenced in his presentation, also 100.325, we can't regulate anything that has to do with the firearms. So we can't talk about anything. ATF is doing this, whatever other agencies are doing that, we can't do that. All we can do are traffic, we can do hours of operation, that sort of thing. If in fact your business explodes and you've got deliveries all over the place, neighbors can complain, we can bring you back in, and we can actually withdraw, the permit if it's bad enough, of course. But as far as the actual firearm related, we can't touch it. That's, oddly enough, that's just a protected venture, period. It also is covered by some pretty significant regulations. So there's pros and cons, but on the other hand, it is protected by some pretty strict, in fact, probably as strict as any other federal coverage. Anyway, so that's why. But hours of operation, absolutely. Days of operation, absolutely. Parking, so if in fact the driveway doesn't contain it, make the complaint and we can bring it right back in here. Because obviously, especially in residential neighborhoods, parking and street traffic, that's a significant.
Right, and thank you for saying that. I appreciate it, coming from you, definitely. Number 6 does say all parking arising from in-person appointments must be off-street, so that's in there. And again, thank you for reiterating that, that point.
I was
Yes,
going
sir, go ahead.
to say that in the recommendations that all parking is off-street.
Correct.
But, the one thing I don't want to happen is if you all do approve this, is just because a neighbor is upset that you approved it, they have me back here every other month talking about, well, he's got a vehicle parked in the road. Well, what if a family member is there and they park in the road? Because we have one side of the street you can park on, the other side you cannot. And that side of the street that you can park on is in front of my house. And the people across the street from us, they park there sometimes in front of our house. And that's totally fine. But I don't want somebody else's vehicle to cause an issue that is not a customer.
I would hope that in any case as well. I know they get.
Well, they'd follow up with it. It's not a mere matter of making a complaint. They would follow up with it. It would have to have substance.
Right,
There
exactly.
would have to be some substance.
Any other comments, questions, board? Yes, ma'am, go ahead.
If this does get approved, can I request?
Go ahead.
Can I request no outdoor activity for this business? I'm just trying to, if we're gonna conduct a business in my neighborhood, I wanna treat it like a business. I wanna have hours. I wanna make it very clear that there can't be any business happening in a front yard. I'm just trying to protect what my kids see when we're out on a walk.
Sure, I understand. Do you have could you speak to that on the conditional use permit?
Yeah, so under the definition of home occupations under section 2.1 of the ordinance, it has those 3 standards. And that second standard is that there shall be no exterior evidence of the home business outside of a small wall sign not to exceed 5 square feet.
So that would include any,
Yeah, that would include anything that
Meetings.
would, pertain to
okay,
exterior evidence, of this use being outside of the home.
okay.
If we wanted to make it more concrete, we could add the condition just to reflect what's already in the ordinance, but that's up to the board's discretion.
Well, no exterior evidence is pretty
Yeah,
comprehensive.
that's fine. Yeah, as long as
You
it's,
can have a lemonade stand, but you can't sell guns from the table out front.
if it's stated in, the conditional use permit and that's how it's defined, I'm okay with that. That's totally fine. Just wanted to make sure. Anybody else? Anybody want to make a motion? I'll go ahead and make the motion, that we approve based on staff recommendations with the added, condition to have the hours of operation Monday through Saturday, 8 AM to 6 PM for the by appointment only, by appointment only appointments that he has. Is that redundant? If you could help me out there, but that's what I'm trying to say.
Including deliveries.
Well, that's a question. Virginia just raised the point, including deliveries. I just got some books in yesterday that was supposed to be at 10 a.m., and I got them at 9 last night. So, no, that's not gonna, that I think is a problem if we tried to put deliveries on that schedule.
But he
But
says-
on the other hand, you talked about scheduling such things.
Yeah, he
so-
scheduled those
Yes,
deliveries.
so I could schedule them, but as everybody knows, you can only control them to a certain point. So if I say it's gotta be between 8 and 6 and they get behind on their route and they deliver at 6:05, I mean, I can't
Yeah.
control
Can I
that.
make a suggestion
Yeah,
then?
go ahead.
We put a condition on that he schedule them between 8 and 6.
Okay.
And then if in fact occasionally it runs over, I doubt that's gonna be big, no.
As long as it's stipulated that it's scheduled, I think that's fine. Everything else will be out of his control, like you said, with the
And
things
they
that
will have to
happen.
be signed for, right?
Yes, I have
Yeah,
to sign
someone
for them.
has to
Nobody
sign
else
for
can
'em,
sign for
So
them.
that they won't be laying there, what I mean?
Right, unless
yeah.
an additional person is listed on the
That's okay.
application,
Yeah.
like say my wife, then
Yeah.
she could sign for it, but then she has to go through
It has to be
the
signed.
fingerprints and the
Right.
background and all that, for the same application.
So, yeah, I think if you're okay with it, I think I could include that in the motion for the by appointments and for the scheduling.
And
of
scheduling
deliveries.
deliveries
You think it's
between the
okay
same
to do?
hours.
Yeah.
Yeah, okay.
I'll second.
Do you want to read it? Just to make sure when you're done there?
Boy, you're such a picky person.
That's your last go round.
Dang.
All right, the motion would be to approve it, based on staff recommendation with the hours set Monday to Saturday between 8 and 6 p.m. All customers be by appointment only, and deliveries will be scheduled between those same hours of 8 a.m., 6 p.m.
8 AM, 6 PM. Yes, sir.
Okay, and
That-
that's your motion?
That would be
for
my
second.
motion.
Yep.
Jenny, your second? All those in favor? Aye. Any opposed?
No.
One opposed?
Okay.
So the motion carries, passes as presented,
And it's gonna pass anyways.
and that's it for the applications. Oh, yes, yeah, we do have to do one final thing before we close, so if you could give us a moment to do that. Do we have to wait for the room to clear on that? Okay. We have to do election of officers for the next 12 months. It was supposed to be last month, so I don't know if we could do that, what's the word I'm looking for?
Just for the calendar year?
Retroactive, or what you need to do.
For the
but-
calendar year 2026?
No.
No, it carries
it's
over.
March to March.
It's March
Okay.
to March.
Yeah.
So I don't know if we need to
Whoever's
do,
in, or gonna be in, has already lost a month, because we should be electing next
okay,
time,
okay,
March again.
okay, gotcha.
Staff's one recommendation as you guys move forward on this is, it may be beneficial to nominate as a suite. So just go ahead and pick your president and vice president, or chair and vice chair at the same time.
Yeah, we can do that. Where's Clem?
She stepped out.
She's ducking that so she doesn't get named in any of this.
Clem, did she go to the bathroom?
May be beneficial to take 5.
Can you? Is she out there? Is she out there? Is Clem out there? Okay. Well, we'll take a minute or two until she's back. I'm sorry. I just want to make sure everybody's here. Clem, where did you go?
People that residential is gonna be, you know, because we've had this case before, the residential and the gun thing before. That this is the way it is now. You can't
Okay.
just decide, people can't, you know.
All right, so we're doing the election. Go ahead.
Yeah, if I could add just one thing. Staff has been made aware that Ms. Stewart is going to seek to leave this body.
Right.
In the future, so just don't nominate her. For
And
anything.
I did, I don't know if it's okay, but I did check with Frank when he messaged me about it. I asked him if he was interested, and he said no. So,
Yep.
we basically have here who we
Just
need.
you guys.
So I can ask for self-nominations first, correct?
You can ask for any kind of nomination you want to ask for.
Does anybody want to nominate for chair or vice chair? I mean, I've done it the last few years, so it'd be good if somebody else.
Have you already had it 2 years, really?
I think so.
Because I was thinking this was your first year.
I think you pulled this on me last year.
Well,
I'm pretty.
I try to pull these things as often as possible.
I'm pretty sure, which, if it is 2 years, which I'm pretty sure it is, would that discount me from the chair and the co-chair?
No, it just keep you from being chair a third time.
Wait, I'm pretty sure that that is the case. Would anybody like to, thank you.
I thought you was gonna be chair.
Would anybody like to nominate
Co-chair this
themselves?
past time, so it depends
Would
on-
anybody like to nominate themselves or someone else?
Oh, let me make sure, put my hands down. I so very out.
Come on, guys.
I may raise my hand by mistake or scratch or something. I thought Jeremy,
Looks like it's by default, so if you served your 2, then I'll become chair,
Yeah.
because I was vice chair,
Yeah.
so,
Would you like to nominate yourself?
I guess. I didn't have any intentions of doing it either, but it doesn't look like anybody's stepping up. So, we gotta do what we gotta do,
are you gonna be the vice chair?
yeah.
Would anybody like, so I'll nominate Jeremy to be chair for the next session. Yeah. I know it's gonna go until March, so that's why I wanted to say that.
So you know my appointment's up in December, right? But I've already addressed that question.
You've already been here 4 years?
No, I've only been,
I was say, where the hell have I been for?
no, I'm not been. I came in filling Michael Crisp's term.
Oh,
2
okay.
year. So I posed that question already because I was
Yeah,
like, my term
okay.
comes up in
So
December.
you'll be up
but-
for reappointment, and you
I've
can
just-
still have 2 4-year terms.
Yeah, I've asked like how they address that, because if they know somebody wants to extend, do they have to wait till that time? Or can they just go ahead and say, hey, put me in for this?
The city likes to do it on like an annual basis, so
Right.
everyone comes up with.
Because they'll have a new mayor in January.
Yeah, so they're just gonna probably tell you in December.
So, but we'll have a potential problem, because if that goes out and I'm the chair and they haven't appointed me,
Yeah.
how does that?
I'd say the odds are very good you're going to be reappointed.
Okay.
And in that case too, that's where the vice chair is
Yeah,
a very
right.
important position on this board.
Well, and I need to find out what my timeline is, if it's every 4 years.
Yeah, I know they'll appoint, it's just that timeline, because I looked through their notes this past time.
I
like
think I may
when
be on my second
The new,
appointment.
when Bernie took over as mayor, they didn't appoint
that's
some of these
possible,
people
but it
until
wouldn't
like
be by
February.
Yeah. So,
It's not
Charlie,
like you're in year 6 or 8.
clarify something for me. I know with the planning commission, if your term expires, but nobody else has been appointed or reappointed,
keep
you
going.
continue until such time as the body
Okay.
acts. And so if it falls through the cracks for some reason, you would continue until a decision is made.
I think
would gladly show it.
mine is coming close, because do they let you know if you've been reappointed, or does it just keep going?
We
They
will let you know.
supposedly ask you if
I
you
think we have to
wish to
submit
be.
paperwork again.
Yeah, they
like
do ask if you wish,
application.
and then,
Okay,
Yeah.
because I think my 4-year might be this year. I think 2022 sounds right from when it started, so, but I'll find out. So, is everything good to nominate Jeremy as chair?
And if there are no other nominations, how about a motion to nomination cease, and a second, and a vote, and then he's got it, and then you talk about your vice chair.
Okay,
I move the nomination cease.
and does anybody have a second? For that? Ursula, thank you. All those in favor? Aye?
Aye.
Any opposed? Okay, motion carries for that nomination.
Yeah.
Would anybody like to nominate themselves or somebody else for co-chair? Vice chair.
Vice chair, yeah.
Now who's being picky? Call him out. Co-chair.
He's insisting, isn't he?
Oh, did I say it wrong again?
Yeah, vice chair.
I thought I said that first. This is a long night. Vice chair. Anybody like to nominate themselves or somebody else for vice chair?
I nominate you for vice chair.
Thanks, Jenny.
That's what I was gonna do too, but I couldn't remember your first name.
Clem. Nate Schwartz. Nate Schwartz. You got this.
I know. I know.
If I see you peek at that name tag. That is, yeah, I'll vote on it, so. Would anybody like to second, any other nominations? Or does anybody have a move to cease nominations?
Do we have to have a second to my motion?
Yes, eventually.
I second.
You know, sometimes they do second nominations and sometimes they don't. We don't usually. That doesn't mean it's correct.
Oh, okay.
I think Roberts probably says we ought to have a second, but.
So-
I second.
And can anybody, offer to cease nominations as well?
Yeah. Put on a motion, how about it?
I move we cease nominations for vice chair.
Thank you. And a second from Clem. All those in favor? Aye.
Aye.
Oh, who seconded that?
Clem.
Clem.
And all those in favor? Aye.
Aye.
Also, any opposed? Okay, that, motion passes, carries for the nomination for vice chair.
Now we're done?
No, really, we're not. I have a question. I got an email about some classes we supposed to be taking.
The CE,
I don't quite understand what I'm supposed to be doing.
right there, that one.
Okay, right.
I got it, I sent the email, I'll talk about it.
Okay,
She's been corresponding with me because I asked the same question.
yeah.
So, the state requires that you receive a certain number of training
Yeah.
for your term of 4 years. What I sent to you guys was through the collaboration with, Kenton County, they have a
Yes.
system, and so I went through and vetted a lot of them and removed several items that I believe were not applicable.
Okay,
What it kind of referenced, they like break it up into quarters, so when it was like credited or when they put it in there, what the topic is, what the link is, and then like what the date it was published. If it's on that list, you can watch it and then just tell me one fun fact about it and we'll credit it accordingly. You just have to email me saying that you completed that training requirement.
so I take the class and let you know I
Yes.
took it? Okay.
Is there anything in person or?
At this point in time, I've not published anything in person.
Okay.
There are some in-person events that have been kind of occurring, but they tend to be like several-day conventions or training sessions, so if you guys would like to do any of those. If you find one, so if you are for some reason going on the KLC website and you find a training that you really are interested in, or if you get emails from UK as a former UK grad and they're talking about sustainability summit or other events, you can request to use those ones and we can look at them. And then I believe we do have a training budget and we also can encourage some of those.
So
but-
just like any other CE that the ones that you sent us, you need to watch it and then
Yeah.
answer periodic questions and then email you that we
Yeah.
completed it.
Okay,
My general request is tell me when you did it, tell me which one you watched,
okay.
and then tell me like one thing that you kind of learned from it, so that we
Okay.
can
From
use
it,
that as
okay.
like a.
And I know
It's for the
I ask you this all the time. What's the number we need to hit again?
Within 1 year of appointment, you have to have 4 credit hours, I believe, and within your 4-year term, you have to have 8. And 7 of those are on any topic, and then 1 of them has to be associated with housing, supply, and affordability.
And would you be able to tell us if we checked with you that?
Yeah, Noah's.
Where we're at?
Now that he's your primary staff
Okay.
planner for the board, he's been keeping
Okay.
a record.
Okay.
So we can potentially have that produced or sent in an email for the
Appreciate
next
that.
meeting.
Does that 1 year tie to when you're first appointed or when you get appointed for a new calendar year?
It's when you're first appointed, kind of as the first ever time, here's what zoning is,
Isn't
type of
that
thing.
8 hours for the whole term?
Yes, the
It
state,
used to be 4 when you started, and then, or was it 8 when you started, 4 a year after that?
Oh, wow.
it varies from
This
board.
is no requirement at all.
Yeah, they changed the policy pretty recently and codified it in state, in KRS 100.
I mean, the ones we did already was already a 3.
Yeah,
Yeah.
and you had, like, the one that was most recently
At
occurring.
Did one already?
There was like virtual ones that were on Zoom, and
Okay.
those ones are
Was it
offered.
medical cannabis and?
Okay.
Oh.
I got
That
you.
was a 3.
Oh.
So, yeah, if you watch that one and you received a certificate from KLC, I do need those because we can't log them otherwise.
Okay.
So if you went to trainings recently or within the past 6 months or something, just like send me that so we can,
All
or
right,
send it to
and-
Noah so we can keep a record of it.
Yeah, so I'll check on that, and if you guys could check in over the next month with staff on where you're at and catch up with that, that'd be good.
Yeah.
Okay. Anything else? Thank you, everybody. Meeting adjourned.
All right.